At the A4ID Socio-economics Rights Knowledge Group session on the 28th of March 2012, our speakers, Judith Bueno de Mesquita of the Human Rights Centre, University of Essex, and Solomon Sacco of Interrights, discussed the role of strategic litigation in advancing the protection of socio-economic rights more widely and how this enhances international development efforts. Specifically, they reviewed the jurisprudence supporting and the challenges facing legal claims that seek the enforcement of socio-economic rights, focusing on the right to health and education.
I'm going to go first, and I'd just like to preface my remarks by saying that actually I'm not a lawyer, even though I'm a lecturer at Ethics Law School. My background has been in international law and also policy making on economic, social and cultural rights. However, through a fair amount of exposure, I've built up some knowledge, some expertise in the area. And I'd also like to thank Cara very much for inviting me and Solomon to come present today. Okay, I'm going to mainly focus on looking at on domestic law. But what I'm going to do very quickly is just give you a very brief overview of protection of the right to health in international law, because that's been quite influential on the development of domestic law and jurisprudence on the right to health. So the right to health, as well as actually the right to education, it's broadly similar, are protected in a range of human rights instruments which date back to the Universal Declaration on Human Rights, which was adopted in 1948. And despite the fact that this right has been enshrined in the majority of international human rights treaties, as with other economic, social and cultural rights, the right to health has been very much neglected compared to civil and political rights until the 1990s, and that was really a function of the Cold War, and it was also a function of the fact that social and economic rights, as I'm sure you're all aware, aren't a strong feature of our own human rights traditions and that of many other Western countries. At the same time, while there were greater associations of socio-economic rights with the agendas of the Soviet bloc, those countries were much less interested in developing international standards and enforcement. So there was little impetus to actually develop standards for practice. Okay? That all began to change with the end of the Cold War. And here I've just noted a few very key developments for economic and social rights, mainly as regards their justiciability, their implementation through courts or at the national level through UN treaty bodies. So in 1999, the CEDAW committee, the Committee on the Elimination of Discrimination Against Women, adopted an optional protocol to that treaty, which allowed individuals to take individual or group complaints to the treaty. And you'll see in the last bullet on my slide that in 2008 and 2011, the CEDAW committee has given rulings in 3 key cases on the right to health, or on health actually. It's not framed in terms of the right to health in the CEDAW treaty, and those cases concern forced sterilisation, maternal mortality and abortion, access to legal abortion services. In 1999 and also in 2000, the Committee on Economic, Social, the CEDAW Committee, and also the Committee on Economic, Social and Cultural Rights, which monitors the International Covenant on Economic, Social and Cultural Rights, adopted general comments on the subject of health. And those general comments served to shed a lot of clarity on the nature, on the scope of the human rights, on their content. Until then, we had very little idea about what the right to health actually meant. And those general comments, particularly the general comment 14 of the Committee on Economic, Social and Cultural Rights, are explicitly referred to in a lot of the national cases, key national cases on the right to health. So that's been very influential as well. Similarly, in terms of clarifying international standards, a special rapporteur on the right to health was appointed in 2002. Special rapporteurs are procedures which are appointed by and report to the UN's primary political and human rights body. In those days, in 2002, that's the Human Rights Commission. Now it's the Human Rights Council. And those rapporteurs do a lot of work and do a lot of reports on unpacking the nature of rights. And then in 2008, an optional protocol was adopted after many years of discussion to the Covenant on Economic, Social and Cultural Rights, and that requires 10 signatures to enter into force. There's currently, I think, 8 signatures, 8 states signed up to it. So it's very, very nearly there, and that would allow, again, individuals and groups to take complaints under that mechanism, which is, I think, quite an exciting prospect. Okay. So just before looking at the national level, I just want to say, in terms of the content of the right to health, we must be talking about the right to health because that's a concept which many people find quite opaque. Generally speaking, the work of the Committee on Economic, Social and Cultural Rights has confirmed that it's not a right to be healthy, it's a right to certain freedoms and entitlements which guarantee the highest attainable standard of health. It's subject to a range of criteria like the available resources that are available to the state. States aren't expected to implement everything immediately, but over time, more is expected of developed countries than developing countries. And there's a framework which the committee uses, which is to say that goods and services for health care must be available, accessible. Available means geographically available. It means that it should be, the services must be available within the state. They must be geographically accessible as well as financially accessible on the basis of non-discrimination. They must be acceptable, which gets at issues such as whether they're sensitive to gender and to the rights of indigenous peoples, whether medical ethics are being respected, and lastly, they must be of good quality, which I think speaks for itself. Also, states have obligations to not only respect the right to health, it's not just a negative freedom that they shouldn't infringe, but also to protect the right to health against harm by third parties and to fulfill it through undertaking a range of legislative, policy, budgetary measures. So I just mentioned that framework because actually, the majority of cases that you find at the national level do sort of fit into that framework, so it provides an interesting and useful overarching framework to when you're considering what's being addressed at the national level, although of course different courts between countries and even within countries take quite different approaches in terms of how they interpret the right to health and also what states should be obliged to do. So at the national level, the first time I saw this statistic that over 2/3 of countries' constitutions protect health or healthcare, I was quite surprised by that it was so extensive worldwide. There has been an increasing range of constitutions that have included the direct protections of health. That's partly because a lot of new constitutions that are adopted in the 80s and 90s, for example, in Colombia and Brazil and South Africa, then incorporated protections of the right to health. The right to health is protected in various different forms within constitutions. So in some constitutions they're recognised as fundamental rights. In other constitutions, fundamental rights are normally confined to just civil and political rights, or sometimes also the right to education. But the right to health isn't always there. In some cases, so the Indian case at the bottom of my list of 4 landmark cases, for example, courts have interpreted civil and political rights like the right to life to include a right to healthcare. So there's an indirect protection. Some constitutions, like the Indian Constitution, for example, have a range of directive principles of state policy recognised within them, which aren't necessarily weren't originally intended to be kind of directly subject to litigation, like the fundamental rights were. But you know, the way it's evolved, those have been very influential on how fundamental rights have been interpreted. And in some countries, like our own, there's not a right to health recognised, or I shouldn't say our own because we're not all necessarily from the UK, but you know, the country we're in, civil and political rights protections, such as those enshrined in the Human Rights Act, to some degree do give protection in relation to healthcare claims. So again, for a long time there was quite limited case law on the right to health, and it was about the same time as things started happening at the international level that the case law on the right to health really started to increase. That was partly as an influence of the general debates evolving on economic and social rights, as well as the increased numbers of constitutions which were useful for litigating economic and social rights. I'd also say that there's been a lot civil society and some international NGOs into rights is one of them, but also the Centre for Reproductive Rights and the Centre for Housing Rights and Evictions on relation to housing, not so much on health, have been very active in supporting national as well as international litigation on economic and social rights. So, and there's been a lot more networking at the international level through various NGOs and just using the internet and communications technology. So civil society has become much more connected, and that's allowed a lot of kind of cross-fertilization of ideas and sort of created a more comprehensive global movement really for litigation. Also, of course, in the 80s and 90s in relation to health, and up to this day, there were particular challenges to healthcare which were very questionable from the point of view of the right to health. So one of those was sort of very neoliberal healthcare reforms which were being promoted and by international organisations, and as a kind of product of structural adjustment policies. So much more limited funding for healthcare, pursuance of things like user fees, an idea that the state should have a decreased role and the private sector should have an increased role. And then there are other challenges like the development of international trade law, and particularly TRIPS agreements, which were influential on some key right to health issues like access to medicines. I'm going to talk in a minute about some common themes, but I just, in terms of the challenges of health rights litigation, but I just wanted to quickly highlight a few cases just to give you a flavour of the different sorts of issues which are being and approaches actually of courts in relation to the protection of the right to health. So the first case I'd like to mention is this South African case of Subramoni, and Subramoni was an individual who required dialysis in order to preserve his life, and but he was initially he was receiving dialysis through a private healthcare institution, but his funds ran out and he was then denied access to treatments within the public health sector. And he challenged this decision under the South African constitutional protections of a number of rights, but the right which actually ended up being the axiomatic right in the case was the right to emergency medical treatment. And the court found that that Subramoni didn't actually have a right to access this treatment, and this is for a number of reasons. Firstly, the hospital had limited resources, and it wasn't able to provide renal dialysis to every patient or potential patient who needed it, and because of that they developed a set of guidelines which would prioritise certain patients, and this due to the terminal nature of his condition if he wasn't receiving dialysis, and the fact it wasn't going to improve, as well as other health complications, he fell outside the sort of priority cases, and so he wasn't able to access the treatments. But the court found that the hospital, because of limited resources, had actually instituted a rational a sort of rationing process, a policy. Secondly, there was a distinction which is more challengeable, I think, which is about whether or not his treatment constituted emergency medical treatment, and the court found that this wasn't an emergency. Emergency medical treatment is a right under the South African Constitution, and the court said this wasn't an emergency because it was a chronic, ongoing condition rather than something which was emergency like traffic accident which sort of arose overnight. So that's one case, and I mentioned before this problem of the availability of resources, so states having to give effect to economic, social and cultural rights, but that's only dependent on the resources that are available. Now, the court could have said actually the state needs to devote more resources to healthcare, and that's certainly been the approach in some other cases, and I'll come on to talk about that. But in this case, the approach was that there was the state had to divide up the pie, if you like, in a sort of rational way rather than increase the size of the pie, if you like. The second case, which is a contrasting case really, also South African case, it's probably the most famous case regarding the right to health. This is the case of the Minister of Health versus the Treatment Action Campaign. And in this case, this case involved access to novarepan, which is an antiretroviral drug which prevents mother-to-child transmission of HIV/AIDS. And a pharmaceutical company had offered to supply novarepan to South Africa free for about, I think it was 5 years. But due to a number of reasons, the then Minister of Health in South Africa didn't take up that offer. Instead, she preferred to provide a much more limited program of novarepan, and they wanted to undergo a sort of testing period where they'd limit provision of this drug to 2 testing sites per province. It was also available in the private sector, has to be said. But that denied access to many women this important drug which can help preserve the life and health of their children, infants. And the South African court found that the Constitutional Court found that this violated, amongst others, the right to health. And key to the decision was the fact that there was international consensus on the effectiveness of novarepan to prevent mother-to-child transmission of HIV/AIDS, and also the fact that there weren't significant resource implications involved in this case. That was different to the Supermoni case. Now, one of the things that's really interesting about this case, as well as some of the other cases, which I'll mention, is the very far-reaching sort of structural nature of remedies which are awarded by the court. So it wasn't just about about individual remedies. It was a very forward-looking decision, and the court, among others, requested the government to extend the availability of novarepan to hospitals and clinics, provide counsellors, and to take reasonable measures to extend the testing and counselling facilities throughout the public health sector. Now, another key issue which arises in this case, which is also a factor in other cases, is to do with implementation of the decision. And these cases involving structural change do obviously have quite a big. They're not easy for a state to implement always, and actually it took continued sort of demands from the Treatment Action Campaign and others, and continued lobbying advocacy for the decision to actually be implemented. And as a result of the decision, it's a tremendously important decision. It's estimated tens of thousands of lives have been saved. So, social rights litigation can have a real impact. The next case is a Colombian case, which I'm a bit less familiar with, so I'll refer to my notes. And it's it was a decision of the Colombian Constitutional Court, and it was a review of 22 tutela actions which were caused by systems which disregarded the right to situations which disregarded the right to health in Colombia. So there are 22 different cases here, but the court decided to review them all together. And the main one of the main interesting things about this case is that it's, again, it's about the sort of structural remedies which were awarded. It wasn't just talking about the, awarding remedies to the 22 individuals who are involved, but the court actually requested the government to update and clarify health coverage through insurance plans, devote more resources into the system, and to evaluate and supervise the companies which supply sanitary services. And there's a lot of ongoing work to ensure implementation of this decision. There's some action that's going on within Colombia by the government, but there's, again, ongoing kind of pressure which is being brought to bear on the government. And fourthly, is the case of Lakshmi Mandal in India, and this concerns this woman who died in pregnancy because she was refused access to essential maternity care, which she was actually entitled to, but she wasn't able to produce the documentation which would have secured her access to hospitals. So she was sent away from various state hospitals and sent home, and she gave birth 2 months early and died immediately afterwards. And again, in this case, the High Court found there was a failure on the part of the state to implement pre- and postnatal services to the woman, and it was inappropriate to place the burden to require people living in poverty to provide evidence of their entitlement to health care, and actually government should be facilitating their access to services. And again, this is a case which has sort of far-reaching structural requirements. So for the individuals concerned and their families, for the families of the woman who survived the woman, there was individual compensation and red cards to ensure them entitlements to healthcare and nutrition. And then that the court also determined that the schemes relating to the provision of healthcare to pregnant women needed reforming. Access to healthcare services should be available across states, and that there should be clarification about gaps in between different schemes of entitlement, as well as requiring governments to collect additional data on the percentage of home deliveries to help the improvement of service provision. Actually, that's an interesting point which I wasn't really going to talk about as the main focus, but there's been a lot of use of indicators and data, a lot of focus on data collection in relation to social rights litigation, both use of data in cases, but also requirements by courts on countries to monitor the situation better through collecting data, which obviously has an important function in policy development to make sure that policies are appropriately targeted. Okay, so just to close, and I think for me a number of key themes and questions arise. Well, firstly, a key theme is the key areas of protection in relation to the right to health. The first of which is sexually reproductive rights, and a lot of cases in Latin America, a lot of regional and international cases as well, particularly on the issues to do with abortion. So access to abortion where it's legal through clarification of, through clarification of where it's legal, and also providing information to people, as well as challenges relating to exceptions to, as well as courts requiring a broadening of exceptions to criminalisation of abortion. So, and then there's maternal health, these new maternal health cases, which I think are really important development. Secondly, access to drugs, and many of the cases concern access to antiretroviral drugs, but there's also a number of cases regarding access to generic drugs as well. Thirdly, there's a number of cases which aren't always framed in terms of the right to health, but are sometimes framed in relation to other rights, but that's cases involving access to food, water, housing sometimes as well, education, so some of the key issues which have a bearing on people's health. And finally, there's quite a lot of cases on mental health, and that's both relating to the conditions in psychiatric institutions or treatment of people with mental health problems within those institutions or within prisons as well. There's a number of challenges regarding litigation. I've presented to you 4 cases which are really quite positive ones, but in many countries the situation isn't that positive, and there's still very fundamental debates about whether courts should actually be making decisions about economic and social rights at all. And that partly reflects discussions which I think are outdated now, given what we can see in some countries and at the international level about whether ESC rights are suitable, justiciable, whether they're theoretically or in practice suitable for judicial determination. And that relates to a couple of key questions. Is it anti-democratic for judges to make decisions about social policy? Shouldn't that just be the role of the executive and the legislature, according to the sort of separation of powers? Of course, you can then come back against that argument and say, well, the judges are there to be checks and balances, to play that role of keeping the executive and the legislature in check, making sure they're actually doing what they are meant to be doing, and also the fact that marginalised groups who tend to be the focus of many of the cases aren't well represented anyway in democratic processes. And what are human rights about if they're not protecting the rights of marginalised groups against protecting them against marginalisation, essentially. Secondly, a challenge is access to courts. So in many countries there's limited access, whether that's because the rights aren't well protected, whether it's because there's limited knowledge about health and other socio-economic rights being human rights, whether it's because it's very expensive to access courts, or the courts are perceived as being pretty inefficient, and also there's also the problem that the judges themselves aren't always very sympathetic to economic and social rights. Thirdly, a very, very big question is about whether social and economic rights litigation can actually enhance social justice. Does it result in equitable outcomes? And there's a significant difference between different countries. So there's some interesting research that's been done on Brazil, for example, which shows that there's thousands and thousands of cases on the right to health being taken in Brazilian courts, and a lot of those cases are taken by middle-class people who are litigating under the right to health because they've been denied access to medications which aren't available on the public health service, basically. So to kind of get access to drugs. So there's a question mark about whether that's really getting at issues to do with equality and non-discrimination, which are really at the heart of human rights. And that's very different from the approach in things like subramoni, where there was this sort of rationing approach, and the South African and Indian cases, which were about entitlements of the poor. And finally, there's the question about remedies, what remedies are being awarded. And as I said before, some of these remedies are really wide-ranging, and in some cases they're not as well. So that's perhaps an area of research which I'm quite interested in looking at in more depth, is just surveying what different courts are awarding to people, because there's a lot of different, even in the kind of very structural remedies, there's a lot of difference between what's being awarded by different courts. And then there's also a question about implementation. Not all the decisions are being well implemented. It has to be said that the human rights community hasn't always been very good at following up on implementation. It's become a recent focus. So everyone used to celebrate when there's a positive decision for ESC rights, and then slightly neglect what the follow up to it. And then there's also the question of whether litigation, bearing all that in mind, is the most effective strategy. And of course, there's a range of other strategies for vindication of social and economic rights. So many development organisations and NGOs and UN agencies and governments are adopting rights-based approaches, and that's much more of a proactive approach that's basically trying to protect these rights within laws and policies before the violations occur, and if you like, the litigation is about cleaning up after the violations occur. So I think that they're complementary strategies, and so I'm not saying that one is better than the other, and it's going to depend on the country, the situation, the government, whether it's open or not, and so on and so forth. And just before handing over to Solomon, I just like to flag, maybe I'll just leave it up there, I don't want to write it down. There's a few resources on the issue which you might be interested in reading if you're interested in learning in this area. Thank you.
Very much. Thank you, Cara. Thank you, Jude. Good evening. I'm going to talk about strategic litigation of the right to education in Africa. I'm a lawyer working with InterRights, which is the International Center for the Legal Protection of Human Rights. I work specifically in the African human rights system and with domestic lawyers in domestic jurisdictions across Africa. So I'm going to talk to my experience there and to the issues and problems that come up in strategic litigation on the right to education in Africa. I have a colleague who does our litigation on the right to health, and I always say she's got the easier job because people understand health violations a lot more easily than they do violations of the right to education. I'm not sure why, but it seems to be very easy to understand when you talk about maternal mortality, when you talk about access to antiretroviral drugs as human rights issues. But when you're talking about the right to education, it's very difficult for lawyers, NGOs, civil society actors to identify these as human rights issues. So I think one of the problems is stepping back and understanding what the actual violations are. We heard earlier about the international system, the matrix of respect, protect, and fulfill, and then the 4 A's. Those apply to health. They also apply to education. And it's always important to think about the violation, but more importantly, what the state should be doing. And I think that's where strategic litigation often has a problem when it comes to education, because we're never quite sure what the state should be doing. This is partly because of the Cold War. After the Cold War, people who were working for equality, social rights, the failure of the Soviet system, it's simply assumed that economic social rights would achieve a lot of those goals. But there was very, outside the lawyers, there's very little sort of understanding of what those obligations would be. And I think we have to think of the enforcement of economic social rights as a much more limited project than we sometimes think. And we need to think about what are the specific obligations. I just wanted to add one thing about progressive realization within the obligation to fulfill. The international, the regional, most domestic laws systems will consider that the obligation to fulfill economic, social, and cultural rights is a progressive obligation. It's not immediate. And I think that's the explanation for Subramani, for example. To some extent, other South African cases are trying to explain what progressive realization means. And different systems have come up with different explanations and different hooks on which you can tie the obligation of the state. The UN system, for example, talks of immediate obligations, one of which is minimum core obligations, which is very important for the right to education, but I'll come back to that. In South Africa, after Subramani, in other cases, they've developed what they call a reasonable review mechanism, which is to say that, yes, the right is realized progressively, but you must have a reasonable policy, and you must have reasonable decision-making in the implementation of that policy. And that was the basis for the TAC decision, and perhaps a better decision to read on that would be Grootboom, which is a housing case, but it establishes the general principles there. So moving on from that, if you're working in Africa on strategic litigation, the right to education, you have a number of questions you have to ask yourself. First, what the obligation is, then the question of what forum you go to. Domestic courts, right to education, like health, is protected in a lot of constitutions, mainly as directive principles, but there are some countries such as Malawi, Kenya, South Africa that protect these rights as immediately justiciable rights. So you have domestic law. In other countries, you have discrimination law, such as Zimbabwe, where there's no protection for the right to education, but there is a anti-discrimination clause in the constitution, which can be very useful. You then have sub-regional courts in Africa. These are courts established under the economic communities. They are, we call them gangster courts, don't quote me, but they are mainly economic community courts, so they don't have expertise on human rights. But if you have a strongly emotive human rights-ish case, like slavery, torture, etc., they will understand those issues and they can be very good in that. But when it comes to some of the more complicated cases, they may be less useful for you. At the African Union level, you have the African Commission, the African Court, the Committee on Rights and Welfare of the Child, are the three main bodies that will deal with right to education cases. The African Court is what we're all hoping will rationalize the human rights system in Africa. It's a new body. It only has jurisdiction over 5 countries at the moment, but we are hoping that it will give a more enforceable role. It'll have a more enforceable role. And then the UN system, just to also say that we're hoping that the optional protocol will also open avenues there. The next question, which often is not asked by domestic lawyers when we're dealing with these cases, is why litigate? Partly the question that Jude sort of ended with. Are other strategies not better? Often they are. I think advocacy, politics, development interventions can be more effective in realizing economic social rights. But once you've accepted that those strategies are not working, I think you then start thinking about litigating. Even there, you need to be very careful, and I find often lawyers are not very careful in thinking about the strategic impact of a case. What they're trying to achieve is that if they're trying to change the law, if they're trying to interpret the Constitution, if they are dealing with a gap in practice, and all of those questions will determine the manner in which you develop your case. And obviously, your client may have a different objective to you as a strategic litigator. So that's a contradiction that strategic litigation brings up for a lot of lawyers. I think we suffer a lot the after effects of the Cold War, because a lot of the cases in Africa are still at the justiciability level. And I'm talking about South Africa, Africa outside South Africa, because within South Africa, there's been a lot of development about what the standards are, what the obligations are. But if you deal with a lot of other countries on the regional level, it's still the suspicion of economic social rights. And this suspicion is not just judges, it's also lawyers. So lawyers are not trained on economic social rights in university, do not necessarily have an understanding of what I think is actually quite a difficult comparative to other human rights law field. So you have, for example, Serap versus Nigeria, which challenged the failure of the Nigerian state to provide universal primary education. This was taken at the sub-regional level in the ECOWAS court, which is the community in West Africa. Now, all it says is that the right to education is justiciable and that the Nigerian state has the obligation to provide education. It doesn't go further than that. And that's because that's what was argued before the court. The lawyers were mainly concerned that money that had been allocated towards education was being stolen by corrupt government officials. So there was very little concentration on what the obligations of the state were towards children across Nigeria who were not accessing universal primary education. It's a very good first case, but I think a lot more thinking needs to be done around what the state should be doing rather than simply saying that it's not providing education. I've essentially gone through the different obligations and sort of picked out cases that I think demonstrate what has been done and what can be done with the different obligations, particularly availability, accessibility, quality. So at the African Commission level, you have one real case on the right to education. This was a case that came out of basically a collapse of society within the then Zaire. It wasn't quite a civil war, but there was a lot of low-level conflict. The government shut down universities and schools because a lot of the opposition to the government was coming from secondary schools and universities. And the decision simply says that that is unacceptable. So you can think of this as an availability, or you can think of it as another immediate negative obligation of non-retrogression, and that they were providing the access to education, and then they removed it. Now, what particularly interests me when I'm dealing with education is free primary education. I said earlier that one of the ways that the UN system has dealt with the problem of progressive realization in the Covenant is to create this concept of a minimum core. And this is very much soft law. It's very difficult often to understand what the minimum core obligations of a particular right are, despite the general comments. But with universal primary education, there's very strong indication from the Covenant itself that the obligation to provide free primary education is an immediate one. And it's considered the basic, one of the basic minimum core obligations of the right to education. So there are cases in South America. I've got one there. Outside of South Africa, there's been very little, and then the Serap case. There's been very little litigation about what this actually means. If you read UNICEF reports on Africa, they will talk about how successful sub-Saharan Africa has been in realizing universal primary education. So you have enrollment rates quoted of 80, 90, 95%. But this is enrollment rate, and this is a cheat, because the completion rate for Malawi is 30% and the enrollment rate is 85%. That means that only 30% of children finish primary school. So I think a lot of areas for litigation are going to be around what does universal primary education actually mean? What are the obligations of the state? And how do you enforce that in the courts? Now, South Africa, I think, although not perfect, it has developed quite a strong enforcement mechanism, jurisprudence around economic, social, and cultural rights. And it's beginning to deal with the problems of universal primary education But because of the nature of the society there, most of the cases are still tangential in that they deal with different issues around school governance, around the existence of public schools on private property, the attempts by private landowners to evict public schools from private land. But they've begun to say a number of interesting things. One is that they've confirmed that universal primary education or basic education is not subject to progressive realization. So that, under South African constitutional law, is an immediate obligation. They've said that third parties have a constitutional obligation not to interfere with the enjoyment of basic education. So a private landowner may be restrained in evicting a public school if there is no other reasonable way in which the government can provide education to those particular children. So I think that that's going to be a very interesting area to look over the next 2 or 3 years. There are 2 or 3 very interesting cases around universal primary education in South Africa. Before I go on to equality and non-discrimination, there was a case in Swaziland, because in Swaziland the right to universal primary education is a justiciable right. It's protected in the Constitution and it's of immediate force. So a case was brought at the first instance in the High Court. An order was made that the state was failing in its obligations under the Constitution, and then nothing happened. You had a declarator, which is very common in the domestic level in Africa, that lawyers will simply ask for a declaration that the constitutional right has been violated. That didn't remedy the situation at all. A subsequent case was brought to enforce that one. It came before a new judge who said, hang on a minute, we can't afford this. We can't expect the government to immediately provide schools and teachers and resources to everyone. So yes, the Constitution says this, but I'm not going to order it. And that went to the Supreme Court, and that was confirmed by the Supreme Court that you can't expect the government to immediately provide basic education. So it's clearly very much a contested area that still needs a lot of thought. Because to some extent, I actually understand what the Second Court was saying. If you have a country where 70% of the school-age children are not in school, how does the state respond to a judgment to the effect that it must provide immediate universal primary education? And I think that as strategic lawyers working on this, we have to think around those questions, around remedies, around resources. But the easiest obligation on which to base a case on most economic social rights cases, and particularly on education, is equality and non-discrimination. Partly because I think lawyers understand discrimination more than they do the right to education, and that means that judges understand it more as well. Also because it's protected in almost every constitution in the world. You will have a lot of cases on which to base your arguments, and there's a lot of international standards. My favorite one is a 6-year-old boy who went to school with dreadlocks in a conservative, rich government school, and was told to go home and remove his dreadlock. I've always thought it's a very cute, very unusual decision from a conservative court that would normally rather frown upon unusual behavior by children. But the point is that that particular court seems to give a lot of importance to freedom of religion, freedom of conscience. So a lot of it is about knowing the forum within which you're litigating and knowing which areas you should take first. Another big one is expulsion of pregnant girls in Africa or pregnant students at colleges. Now, in almost all the countries in Africa, including to some extent South Africa, pregnant children from school are simply excluded. It's automatically assumed that they should be out of school. In some countries, this also happens at colleges and universities. So a lot of the decisions have been at the college and university level. So the three that I have here, the Botswana, the South African, and the Zimbabwean cases, all dealt with university and college students. And the courts were very happy. The Zimbabwean case, they sort of fell over themselves backwards to outrule the college regulations, because it wasn't a state college, it was a private college, it was by agreement. They held that there was no way to enforce the constitutional right to non-discrimination, but they held that the agreement between the student and the college were null and void because they were against public policy. So again, it's something that courts will understand quite easily. The second wave, if you will, of this case now start to deal with primary and secondary school children being excluded. And there's one from South Africa. This one's actually the language one. But there are 2 or 3 cases in South Africa dealing with the expulsion of pregnant girls from secondary schools. This one is one I find a little bit more difficult to explain. It's a South African non-discrimination case that I think got lost in translation. Because of South Africa's history of racial exclusion and language exclusion, there are very rich government schools which are very heavily subsidized by the state, but that charge fees and therefore have almost a double income. One of the ways some of these schools have excluded Black and disadvantaged children has been through teaching in Afrikaans rather than in English. So this case was argued on the rights of the state to intervene and instruct the school to provide education to a specific group of children in English. Unfortunately, because it became a language issue, the Supreme Court of Appeal held that although the children had the right to be taught in English, they did not have the right to be taught at English at that school. So they should have been placed in another school within that district that could have taught them in English. I think it's a very unfortunate decision, and I don't think it will last. I think other cases will overturn it. The acceptability, the quality issue that you will get in Africa is the issue of political speech, academic freedom, and how that impacts on university students. So there is a quite interesting decision, Good versus Botswana, at the African Commission, which dealt with a university professor being deported from Botswana for an academic paper he wrote criticizing the status of democracy in that country. I've recently been talking a lot with Malawian lawyers who have had a very similar case in Malawi around a lecturer who was called in by the police and cautioned after discussing the impact of the Arab Spring on Malawi and basically inciting violence as he was accused of by the police. And that led to the the closure of the university for 8 months, and a lot of litigation. There's another area that I call rights in education. An example is corporal punishment. And the second case, Derbler versus Sudan, relates to university students in Sudan who were coming back to the campus wearing Western clothes, were stopped and were quite brutally thrashed as they entered campus. Although it's not directly affecting education, it affects the environment within which education is provided. Just quickly to talk about what we're doing now with the right to education. We are trying to build up cases at the domestic level to incorporate international and comparative law, mainly in East Africa, but we take lawyers from across Africa. And we sit down with 12, 15, 10 different cases on the right to education, and we discuss this as a group of practitioners and discuss strategies, international comparative law issues. And it's interesting what gets thrown up as issues there. A big issue is the user fees in universities, the reduction in the state involvement in provision of education. Discrimination is clearly the major entry point for lawyers. But fee and non-fee barriers to universal primary education, I think, is a growing concern in countries such as Kenya, Malawi, and Tanzania. Remember, I said that the enrollment rate was 90%, but the completion rate is closer to 30%. And it's trying to work out what the actual problems are and whether those can be litigated and removed. I think the biggest challenge is that, and it's an opportunity, is that no one really knows what the obligations are. We know what the Committee on Economic, Social, and Cultural Rights thinks the obligations are, but that's not cases. It's based on general comments which are, by their nature, very broad and theoretical. So I think there's a lot of opportunity for lawyers to define the limits of state obligations there. Conservative societies, I think, is a serious problem. Persuading lawyers and NGOs in Tanzania, Kenya, Malawi that the expulsion of a pregnant girl is wrong is not easy. You will have one or two strong lawyers who think that it is wrong, but you usually need a bigger consensus around a social issue before you go to court. Resources, I don't think we can get away from the problem of resources. I don't agree with the Swazi court's reasoning, but I do understand that that is a big problem. Conflicting interest, and that's the micro case, that you may have an interest in protecting a particular language, but you also have the interest in ensuring equality and non-discrimination, and that those two issues will compete, and one may be used to defeat the other. And I think the opportunities are in some ways the obverse of that you're beginning to get a legal understanding of the obligations from South Africa, which needs to be queried because I think they've made some mistakes, but does begin to give us a tool. And then I think with education, the interesting thing is that probably it's the most protected economic social right there is in terms of enforceable constitutional provisions. So that's something that excites me a lot in countries such as Malawi, countries where there's a clear failure to ensure that children receive basic education, but there is constitutional protection for it. I think I've talked a lot too much. Thank you very much for your patience.